All right. Good morning. Thanks for getting out on a rainy Saturday morning. We're excited to continue the very interesting conversation that we began yesterday. So the topic of this morning's first panel is liquidation, theory, techniques, and problems. And the members of the panel, Will Baud of the University of Chicago, Steve Sachs from Duke, Neil Siegel from Duke, and Bernie Myler from Stanford. So in order to avoid getting off schedule, we'll just dive right in. Each of the panelists will give some remarks. We'll have a little bit of dialogue, and then we'll open it to the audience for questions. Thanks.
Okay.
Go ahead.
Thank you. So, James Madison said in the Federalist Papers that all new laws, though penned with the greatest technical skill and passed on the fullest and most mature deliberation, are considered as more or less obscure and equivocal until their meaning be liquidated and ascertained by a series of particular discussions and adjudications. This was a theme that he returned to a lot in his constitutional thought in the various offices he held over time. And it's, I think, an important ingredient in how we should think about constitutional interpretation, even though it's not a concept that is always part of sort of modern interpretive parlance. Often the use of history is thought to be kind of precedent or originalism or intellectual history, but it's not, there's no other, people don't always think about another kind of interpretive history, which is this idea of liquidation. So as I'm going first, I thought I'd first just talk a little bit about what it is, how it works with other sort of interpretive methodologies, and then some of the reasons we might want it. So what it is, I mean, the basic idea of liquidation is that when there are ambiguities in the constitutional text, practice and a course of decisions can provide some more definite meaning. So not outside the zone of ambiguity of the text. If the text speaks clearly to something, that's not, Madison thought, something that was up for practice to deal with. But texts never speak clearly to everything, and as to the stuff that the text leaves open, then you care about how the practice has sort of interpreted that term. And then it's not just an idea that like once something happens once somebody does something, that makes it right. The idea was that there had to be a course of decisions, so people repeatedly implement some particular reading of the text, and that can, once there comes to be a consensus in favor of that, then that becomes part of the meaning of the text. So there were examples, lots of them, from the sort of founding to the antebellum period. One of the maybe more prominent ones is Madison's own position about the constitutionality of the national bank. When Congress first passes the bank bill, Madison argues that it's unconstitutional, that it exceeds Congress's powers under the necessary and proper clause because it involves the creation of a corporation, which was expressly left out of the constitutional plan, he said, and that was a sort of a great and important power that wasn't granted to the federal government. But the bill is enacted over his objection over time, and people come to, the court comes to uphold the bank, people come to work under the bank, and so much later in his career, Madison is called on to make a series of decisions as president about what bills to veto and what to do when the bank comes up for renewal, and he changed his course. He says, even though I thought that the bank was unconstitutional to begin with, at this point we've had a sort of a course of constitutional decisions upholding the bank, and I'm going to respect that. I'm going to also help enact the bank and help sort of continue to implement the bank, despite my original views that it's unconstitutional, that the course of decisions had, in his view, sort of expounded the meaning of the Constitution in a different way. He got quite a bit of criticism for this from people who accused him of being inconsistent, people who accused him of abandoning his constitutional principles, people who said, how can practice change the meaning of the Constitution? And he responded, well, it's not changing the meaning of the Constitution. If this were something where the Constitution spoke clearly, I would maintain my position. But practice can expound the meaning of the Constitution even though it can't alter it. On the flip side, there are other examples. It's not from Madison, but later on, during some debates over recess appointments, for decades, the executive branch takes a broad view of the Recess Appointments Clause and the kinds of recesses that can be filled by recess appointment. And they sort of affirmatively, in later opinions, they say, even though this is a debatable question about how to interpret the text, our practice has become a sort of broad interpretation, and so we ought to go with that. And then the Senate in the 1860s responds with a kind of a Madisonian point on the other side. And they say, even though it's true there's been a long practice of these kinds of recess appointments, in our view, the Constitution clearly forbids them for textual reasons I won't go into now. And therefore, this is the kind of practice that doesn't count as a constitutional construction because it's outside the sort of clear meaning of the Constitution. When people use this kind of constitutional practice in scholarship or in argument, I think it's often thought to be an alternative or a challenge to other methodologies, like including originalism. I mean, it's easy to see if you have a methodology that just wants to respect tradition for its own sake, why you would care about constitutional tradition or practice. That is one sort of important strand of interpretation. But I think even people who are more textualist or more originalist can legitimately make use of liquidation. Under some theories of originalism, you look directly to legal interpretive methods that existed at the time of the founding. John McGinnis and Michael Rappaport call this original methods originalism. There are sort of other versions of that too. And even if you don't have that kind of a view about original interpretive methods, because liquidation only works when the constitutional text is unclear, there's nothing inconsistent about being both an originalist about clear constitutional text when its meaning can be discerned, and then having some other version of practice that takes over when the constitutional text is unclear. And I also think there's a lot sort of to be said in favor of liquidation as a normative matter, that ultimately liquidation in the Madisonian sense acts as a substitute for precedent and stare decisis, and maybe as a superior one. So both stare decisis and liquidation are designed to give some kind of stability, some kind of respect to practical decisions within some set of bounds. Everybody believes some practices can be overturned, some precedents can be overturned, but there's some zone where the practice or precedent should control. Liquidation has a couple of differences from precedent that I think are good. One is that it's not just about judges. So judicial decisions count as a part of liquidation. So McCulloch versus Maryland, upholding the bank, that's part of the course of decisions that helps explain the meaning of federal power. But it's not just about judges. And especially, a lot of important constitutional questions are not primarily decided by judges. They're decided in the political branch, they're worked out in OLC, they're debated by Congress, and that kind of non-judicial interpretation of the Constitution is something we should value, something we should encourage, something we should give respect to when it's really helped reach a consensus. And I think it's important and useful to take the judicial role, not sort of keep it out of the front seat and make it one of the seats at the table in terms of establishing constitutional meaning. The other key difference between liquidation and sort of modern theories of stare decisis is that it's not just about one case. So the way we now think of precedent, once the court speaks to something once, that's it, be done. Maybe the court will be called upon to revisit it, but until it does, it's established the rule right away. And that, I think, can lead to kind of attempting to settle things more quickly than our own politics or practices really warrant yet. A lot of precedents are 5-4 decisions that are very close and could go the other way, and sometimes they cut off a constitutional conversation when they should be starting it. Whereas a course of decisions helps to give some weight to the practice and helps to sort of move things along towards settlement, but at the same time it doesn't sort of make it all happen in one go, so to speak. That does mean there are sometimes hard questions about figuring out, when has the course of decisions run long enough that it's liquidated? How do we know that something is liquidated until it's happened? And I think that is a hard and interesting question, but it's the right question to be asking about constitutional precedent and practice. I am inclined to favor the political science formulation. I guess Mark Graeber puts it as something like, settlement happens when the losers give up. And then you see the sort of constituency of when the other side of the debate yields. That's when settlement has really happened. And that does mean sometimes constitutional fights can go on for a while, but they come to an end, and then they allow us to establish precedent and move forward.
Thank you. So thank you all very much for coming, and thank you to the organizers for having me. My talk is going to be, in some ways, a work, going to do work within the sort of originalist wheelhouse. Basically say, liquidation might be new to many people, sounds kind of weird, requires us to look up all this other stuff. We not only have to know the intentions and the public meaning and all those kind of things, but now we need to know all their original methods and whether liquidation was among them and how it's supposed to work. Why on earth would we do that? Why would we go through all that trouble? There's no liquidation clause in the Constitution, so why do we have to do this crazy thing? And my answer will be essentially, in line with the paper that some of you might have heard me give a week ago, that the proper object of originalist interpretation is not necessarily the intentions of particular people, not necessarily the public meaning of a particular document, but what the law was, all things considered, as of the time of the founding. And then I'm going to say why I think that makes sense as a way of doing originalism, why it would have the consequence that we do things like liquidation, potentially, if that was part of the law, and moreover, especially in light of the theme of this conference, what that means for our take on the relationship between law and history and the sort of disciplinary boundaries of doing law. Let's start off, what does it mean to say that the proper object of originalist interpretation is the law as it stood at the time of the founding? So different societies use legal texts in different ways. We know this. You can look around the world. Different people do different things with it. And you can also know this by looking into the past. So, perhaps it was upon a time the practice that Parliament would get together and talk about some stuff, and they'd come to some agreement, and then they'd get somebody who actually knew how to write the thing down. And the text that was produced that way might be a sort of imperfect record of what was actually agreed to, and what was actually agreed to orally was the law. There's a great example of Lord Justice Hengham telling a lawyer, some unfortunate lawyer who was trying to do a statutory interpretation argument before him, "Do not gloss the statute, for we made it, and we understand it better than you." Hengham had been in the Parliament where they discussed this thing, and he knew what the oral agreement was, and this guy was just trying to talk about the text. Why would one do that? Clearly, Hengham knew what the law was better than this lawyer. That's not how we in our society right now tend to use legal texts. We tend to say things like, the text is the law, it's not just evidence of the law, or things like that. But different societies can do it differently. And when we have a text like the Constitution, what we're interested in is not just what does it say, but we also want to know, what was this thing? What was it supposed to do? What relationship did it bear to the law when it was enacted? Because it would be very strange in certain ways to go back and take our particular view of how texts work and import it back to a document that perhaps wasn't supposed to work that way, like some old statute from the 1300s. Now, what the law was at the time, what the Constitution added to the stock of American law, is not quite the same thing as the intentions, even the linguistic or communicative intentions, of the people who enacted it. You might think that you're saying a certain thing, but whether that thing you're saying has legal effect is a different question. On someone like Larry Alexander's model, what we're doing is we appoint some authorities to give us some norms, and then we want to know what norms did they try to give us. But the authorities that we're delegating, the people, the ratifiers, the framers, whoever you select, aren't necessarily these sort of unmediated Austinian sovereigns with power to do anything in the universe. They might have, in some sense, limited commissions to contribute a text that goes into the general body of law, but that has to be interpreted according to existing rules, that sort of has a function according to other things that are already in the law. Or to put it another way, part of the authority that's giving us law is not just these individual people, but the whole world of laws that we already have right now. And so the law as it stood in 1788 is not just a clear, sort of immediate reading of what did people in the ratifying conventions think they were saying. It's a broader analysis than that. For the same reasons, it's not quite identical to the public meaning of a document. You might have a document whose public meaning, certainly to the ordinary reader, is very different from what it does to the law. I think everyone would say that what the ordinary person makes of ERISA is not necessarily ERISA law. Similarly, you might say even the reasonable reader, or the sort of fictive, invented reader, who knows everything else there is to know about the law, whether what's going on there is really an issue of communicative content, or really an issue of meaning, is not entirely clear. It might be simpler just to say, what we want to know is what this text does to the law, knowing the entire corpus juris already, and not necessarily what its meaning is in some more narrow sense. So if we are looking for the original law, so to speak, what the law was in 1788, why would we think that binds us? So people might say, sure, I agree the Constitution is binding, but why am I bound by all these other rules of interpretation and stuff? I think there's two possible answers there. One is, and there might be further, but one possible answer is that it's just a little strange to take a document that was created for legal purposes to establish certain legal rules and not actually look to what legal rules it established according to the legal conventions of the time. In certain ways, it's saying, why be more Catholic than the Pope? Why care more about the public meaning or the intentions of the authors of this document than the society in which the document was created did? It just, that's not a knockdown argument. One still could have normative reasons for caring about that, but it just seems a little strange. Secondly, one might say, look, why should I be bound by all these other original methods, all these other legal rules that are written in the Constitution? Doesn't that sort of give judges a big sandbox to play in if there's a lot more factors they can call up other than the meaning of the text? Doesn't it remove constraints from judges? But part of the problem here is that the purpose of constitutional law is not solely to constrain judges, or rather, it's not measured by how well it constrains judges. Lots of things constrain judges. A rule that judges have to flip the coin in every case and vote for the plaintiff or defendant accordingly is intensely constraining but a lousy system of law. Or to put it another way, if you think that originalism constrains judges, so does always applying the original public meaning of the French Constitution. By definition, it automatically constrains judges just as much. But no one thinks that that's appropriate for judges to do, precisely because the choice of constraint seems wildly unconstrained. Why the French Constitution and not ours? Why not the Uzbek Constitution? There are 1,000 possible answers. And so the thing that constrains judges is their duty to follow the law. And so it has to be a claim that the law requires such and such, that the law might potentially require us following the law as it stood in the framing and as it has been validly adjusted since. So I'm not going to give a full defense of that position. If you want to, there are draft papers I'm working on that I'd be happy to share. But I want to suggest that as a plausible way of looking at originalist interpretation, and then move to the general topic of this conference, which is what does that say about the relationship between law and history? If we want to know what the law was as of 1788, it's in certain ways like asking the question, what the law is in Japan today. The past is a foreign country. It said they do things differently there. When you're trying to answer a question, I teach conflicts. Sometimes it comes up. What is the law in Japan? How does it bear on this question? The way you would find that out, if you're a positivist, is say, well, I've got to find out some facts about Japanese society, and that's going to tell me the answer about what their law is. Somehow the question of law will depend on those social facts about Japan. And in some ways, what I'm doing there is what H.L.A. Hart calls an exercise in descriptive sociology. I mean, it might be armchair sociology. I'm not necessarily going to someone professionally labeled as a sociologist to find out that answer. But it might be, that's basically the sort of disciplinary tool that one would be using. The person you'd actually go to for that question would be a lawyer, either an American lawyer who specializes in Japanese law or a lawyer who actually works and practices in Japan. But that's the sort of things they would be looking for are facts about current contemporary Japanese society. In the same way, if you're trying to answer the question, what was the law in 1788? You're going to have to look to facts about historical American society in 1788. Many of which are divulged through the techniques of history, broadly understood. We're looking for facts about the past. Whether we get those facts from someone who is professionally trained as a historian or a lawyer depends on the sort of contingencies of modern professional divisions and law faculties and history faculties and all that. But essentially what we're doing is a sort of narrow band version of elite intellectual history looking for facts that might tell us what was the law in a given case. And in certain ways, that's standard lawyers' work. So I once had a case that came through a court I was clerking for, where the question was, what was the law on a given topic in 1964 when a crime was committed? For ex post facto reasons, we can't do anything else than what was the law at the time the crime was committed. Similarly, if you have a long, complicated chain of title, you might say, I need to know what the law was at the time this particular conveyance a long time ago was made to know who owns the land today. Or if I'm trying to figure out the borders of Virginia, I need to know something about the grant to Lord Baltimore and what the law was for construing that instrument. So ultimately, it isn't to say that lawyers can sort of do without historical facts. It's rather to say that what seems like historical work often is ordinary legal work. It's just that occasionally our law tells us, go look up some stuff about the facts, about the past, and those facts are going to be potentially determinative. So the relationship between law and history may, disciplinarily be very distinct, but in certain ways they're intimately and necessarily connected. Even when we're asking the question, was this criminal defendant guilty or not, what we're asking are facts about the past. Our law always requires us to look that sort of stuff up, and we might do a good or a lousy job of doing it, but those might be our options under the law as it stands today. Finally, one last question. This has all been a very high level of generality. It somewhat assumes that there was, a good consensus answer on what the law was in 1788, and I want to suggest that there are two areas of disagreement, two ways that we might be unsure of this question, and yet nonetheless, it shouldn't necessarily stop us from asking it. The first way is that we might be unsure about what facts in particular we're actually looking for. So there's long-standing jurisprudential disagreements within the field of legal positivism. Okay, law is social facts, but what facts? Whose conventions matter? Is it a question of what the officials and judges in a jurisdiction do as a matter of internal acceptance? Is it a question of what everyone in society believes the law is? Is it a predictive question about what lawyers and judges are likely to do in certain situations? Those philosophical jurisprudential disagreements are real disagreements, but they're questions that sort of have to be answered within that, using the tools of that philosophical discipline. We have to say, okay, what is the law in 1788? In the same way that we might disagree about what the law is now. We presumably have some, perhaps not fully fleshed out, but some intuitions about how we identify American law and Japanese law and contemporary law of all kinds based on these sort of inchoate jurisprudential assumptions about what kinds of social conventions matter. In large part, we know it when we see it, because the social conventions, fortunately, don't peel apart all that often. Sometimes they do. And so I think this leads to the second family of questions, just empirically, was there a law of 1788 that we can really talk about in some coherent way? I think this gets to a lot of what Professor Cornell was saying yesterday, that perhaps the world of 1788 was just so fully divided, the conventions of different groups in society so distinct from one another, that one can't really hazard any strong statements about what the law was back then. In the same way that during the American Revolution, if you asked, does British law apply to the colonies? Basically, all you could say is, well, they're fighting a war over that right now, and I can't give you any better account than they can. But I think that claim, too, was certainly possible. It's just an empirical question about whether there was law in the United States at the time. Also might not give us quite as much trouble as we think. The United States in 1788 was a potentially very divided society, but it was also not a society at civil war with itself. There was a functioning, though perhaps poorly functioning, central government. It had officials and judges. It had ordinances that the states were at least strongly, politely suggested to adopt on their own. And there was one can say, a great deal, in fact, about the law of the United States as it stood even before the adoption of the Constitution under the Articles and under the Constitution themselves. So while it is a possibility that we might undertake this inquiry and end up empty-handed, I think that claim is not yet proven. So in summary, what we're looking for when we're doing originalist work, I suggest, is what the law was at the time of the founding. That might require us to do strange and unusual things, like liquidation over time, depending on what their rules for legal change were. But ultimately, that might be what our law today commands us to do. And in that case, us lawyers have really no other option. Thanks.
Well, good morning. I'm very pleased to be here with all of you, and I thank you, Michael, for inviting me to participate in this gathering. I should say at the outset that I recently had back surgery, and I'm presently highly medicated from back spasms. And so I just want to warn you in advance, I may stop at some point, stand up, and call for the overruling of Citizens United. And if that happens, just bear with me. I'll calm down. I applaud Will's suggestion that we register the existence of the Constitution outside the courts, and there's a long history as well as present reality outside the courts. And I also want to appreciate my colleague Stephen's suggestion that different societies may use legal texts differently. And what I want to do in my time is talk broadly and generally about how participants in American interpretive practice interact with the text. And I want to do that by using as one of several examples the case that Will mentioned, NLRB against Noel Canning, the recess appointments case presently pending before the U.S. Supreme Court. So the recess appointments clause is in Article 2, Section 2, Clause 3. It provides that the president shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session. The Supreme Court is considering, in this case, among other things, first, whether in light of the clause, the president is limited to making recess appointments during inter-session Senate recesses as opposed to intra-session Senate recesses. And second, whether the positions to be filled must have become vacant during the recess. Now, there's a third potentially decisive question presented, which is whether the president's recess appointment power may be exercised when the Senate is convening every 3 days in pro forma sessions, which is what happened in this case. But that's not going to be my focus here. I want to focus on the first two questions. And at one level, the case is straightforward. It presents conventional debates about the meaning of specific words in the text of the Constitution, including the words happen, the, and recess. But I think there's a deeper, more theoretically interesting level. And at that level, the case highlights uncertainties about the role that such text should play in constitutional analysis when it's asserted to be inconsistent with long-standing practice or other extra-textual considerations. Now, the parties in the case dispute the nature and the duration of historical practice, but it's undisputed that there is a relevant historical practice there. Presidents made intra-session appointments as far back as Andrew Johnson, and such appointments have been common for decades. In addition, presidents throughout American history have used recess appointments to fill positions that became vacant prior to a recess. Now, if the constitutional text is perceived to be unclear, then there's substantial support in precedent for the idea that historical practice might be useful. It might provide a gloss on the meaning of the text, particularly in separation of powers cases, although not limited to that context. And I'm here thinking of Justice Frankfurter's memorable observation in the Youngstown case, the Steele seizure case. He said it's an inadmissibly narrow conception of American constitutional law to confine it to the words of the Constitution and to disregard the gloss which life has written upon them. But my question is, what is one to do? What do Americans tend to do if the text is asserted to be clear, not unclear? Is practice simply irrelevant in that situation? And that's one of the questions I'm puzzling over with my colleague Kurt Bradley in a draft article that we've written. It's called Constructed Constraint and the Constitutional Text. I should add that it is available free of charge to anyone interested. You need pay only shipping and handling. Okay, so during oral argument in Noel Canning, Justice Scalia repeatedly pestered the Solicitor General with a particular question. He said, what do you do when there's a practice that flatly contradicts a clear text of the Constitution? Which of the two prevails? And the SG, having gone to law school, did what you might expect. He responded primarily by fighting the hypothetical. Right? He said the text was linguistically unclear. Historical practice both confirms the lack of clarity, it gives meaning to the Constitution, and that it would be unlikely for long-standing practice to develop in a way that was contrary to clear text. But Justice Scalia, who taught in a law school, continued to press, saying it's my hypothetical and you can't have it. And so in the alternative, the SG maintained that a practice going back to the founding of the Republic should govern. And Justice Alito then posed the same question to opposing counsel, and as one might expect, he gave the opposite answer, that clear text trumps practice. And what I don't want to take sides in that debate, my submission is that these exchanges risk missing an important and overlooked point. Clear text and long-standing practice are not fully separate categories, at least not always. Whether constitutional text is perceived to be clear or unclear is partially constructed by a variety of considerations, including customary practice. And here I'm invoking the idea of construction, of constitutional construction, in a way that is different from how the term is used in some recent originalist scholarship. So instead of distinguishing between interpretation and construction, I view construction in the older constitutional sense of being part of interpretation. And specifically, my claim is that the perceived clarity of the text is not just a function of linguistic conventions about semantic meaning, the meaning of the word happen or the or recess, but that instead the perceived clarity of the text may also be a product of a mix of purposive, structural, consequentialist considerations, as well as historical practice. And what is more, the capacity of historical practice potentially to affect perceptions of clarity is not limited to the historical practice in the earliest years of the nation. So let me give you a few examples, because I think that interpreters often construct textual clarity even if they don't entirely realize that that's what they're doing. So, for example, most interpreters, I think, believe that the First Amendment is clearly not limited to Congress, notwithstanding the first word of the First Amendment. Indeed, in the famous Pentagon Papers case, several of the justices, led by Justice Black, but others as well, ended up saying some unwittingly, in my view, hilarious things about how the text means what it says, but they couldn't even see the first word of the First Amendment. No one even paused over it. It was just so utterly obvious that Congress, right, didn't mean Congress. And if the amendment is clearly not limited to Congress, I don't think it's because of the semantic meaning of the word, which the Constitution itself defines in Article 1, Section 1. Likewise, it might seem that in light of the Constitution's placement of the habeas suspension clause in Article 1, that only Congress has the authority to invoke it. But I think that conclusion becomes less clear in a situation like the one that President Lincoln faced at the outset of the Civil War, when Congress was out of session and the Capitol itself was threatened by the Confederacy. Similarly, historical practice has made it far less likely for interpreters today to draw clear negative inferences for presidential authority from the Constitution's assignment to Congress of the power to declare war in Article 1, Section 8, Clause 11, and its requirement of supermajority Senate consent to treaties in Article 2, Section 2, Clause 2. Many interpreters believe that the presidents are authorized to initiate military options in certain circumstances, and most interpreters do not regard executive agreements as unconstitutional. And finally, and this is regarding the liquidation idea in particular, there may not always be a crisp distinction between clear text that is not subject to liquidation and unclear text that is subject to liquidation. Will was sharply insisting on that distinction. In my view, the liquidation, or the so-called liquidation, may be what ends up confirming the ambiguity in the text in the minds of interpreters. Consider again this requirement in Article 2, Section 2, Clause 2, that the president must obtain the advice and consent of 2/3 of the Senate in order to make treaties and appoint specified public officials. Linguistically, the language seems to suggest some sort of advisory role for the Senate in the negotiating or appointment process. The text doesn't say advice or consent. It doesn't say consent. It says advice and consent. But President Washington didn't want the Senate to play this role, and his so-called liquidation was that the Senate merely is required to approve treaties after they are negotiated. Now, what about the recess appointments clause? Well, Noel Canning argues that clear text trumps historical practice. The federal government argues primarily that historical practice trumps an unclear text. I think a third possibility, which neither side seems to register, is that the perception of clarity is not a fully independent variable and is instead affected to some extent by the practice. In light of the practice, perhaps the word happen could be read to mean happen to exist, an interpretation with a long historical pedigree going back to Attorney General Wirt's 1823 opinion. Alternatively, and there's less of a pedigree for this position, perhaps the word during the recess of the Senate could be read as modifying when the president may make the appointment, not when the vacancy may occur. And perhaps the recess could be read as referring to when the Senate is in recess, not in an event that can occur only once per Senate session. And by the way, this is an aside that I can't resist, Dred Scott, of all cases, illustrates how a narrow interpretation of the word the in the Constitution can be problematic. So in holding implausibly that Congress was powerless to prohibit slavery in American territories that were acquired after ratification of the Constitution, Chief Justice Taney reasoned that Congress's power in Article 4, Section 3, Clause 2 to make rules and regulations for the territory belonging to the United States, and now I'm quoting Tawney, does not speak of any territory, nor of territories, but uses language which, according to its legitimate meaning, points to a particular thing. But I digress, right? I'm going to leave the territory clause and return to the recess appointments clause. Another alternative possibility to the ones I've just sketched is that the clause is not best viewed as setting forth the exclusive conditions under which presidents may make recess appointments. In other words, perhaps in this regard, the recess appointments clause is like the treaty clause. As I just noted, the treaty clause is not generally viewed as setting forth the exclusive grounds for presidential conclusion of international agreements. Akhil Amar, in his recent book, America's Unwritten Constitution, explains that it's always a matter of legal judgment whether to draw a negative inference from particular words in the Constitution, whether to invoke expressio unius and read certain portions of the text as saying all that there is to be said about a particular subject. So the perceived clarity of the text can operate, it turns out, on more than one level. The perceived clarity of the text can turn on what it says, and it can turn on whether it says all that there is to be said. Many a structural argument turns on this distinction. Now, to be clear, I do not necessarily endorse any of the impossible interpretations of the recess appointments clause that I mentioned this morning. I'm here to sell a theory paper that I've written with a colleague, not to argue about how this case or any other case should be decided. I actually think Noel Canning is a difficult case, and it's made more difficult for me by the medications that I'm consuming. I agree. Text is not infinitely malleable, and sometimes traditionally textual considerations, such as linguistic conventions, will trump other considerations, including practice. So I don't want to argue that there's no there, and text is just to be made up entirely. I think it's a lot more complicated than that. And in any event, practice is not the only relevant extra textual consideration for the recess appointments clause. For example, I think there's a serious question about whether the structural purpose of the clause is advanced or compromised when the president makes recess appointments in order to counteract perceived congressional intransigence, which, in my understanding, doesn't seem like the historic purpose of the clause, why the president was given that power. In addition, the consequences of particular readings of the clause are complicated, given changes since the founding in Senate practice and the size of the executive branch. And by the way, the oral argument included a lot of back and forth on the practical consequences of different holdings. And these questions of concern came not only from Justice Breyer. It's one thing for justices to say that the consequences are irrelevant. It's quite another to really mean it while exercising great power. My point about practice is simply this. It may make it more difficult for Noel Canning to lay exclusive claim to the clear text of the clause. Whether its reading or the SG's reading is a more faithful to the clear text may be as much a conclusion as it is a premise of the interpretive argument. Now, whether you agree or not about Noel Canning and how it should come out, I do think that in general, understanding that the perceived clarity of constitutional text is partially constructed by historical practice and by other considerations allows for a more nuanced and descriptively accurate appreciation of American interpretive practice. Thank you.
So thanks so much to Mike McConnell and Judd Campbell for inviting me to speak and also for organizing this excellent conference. My comments today will address this topic of liquidation from our panel in the perspective of the common law. And I want to place liquidation within the longer history of legal change and suggest that while legal practice does assist in understanding constitutional meaning, it may not fulfill the aspiration that some have for it of lending greater fixity to the relevant provisions than the text itself does. In doing so, I too am going to refer to the questions that the justices raised in the Noel Canning case in order to discuss some of the particulars of how liquidation might operate. So as we've heard from Will, Madison discussed liquidation in Federalist 37. And I'll just repeat briefly what he said there. He says, all new laws, though penned with the greatest technical skill and passed on the fullest and most mature deliberation, are considered as more or less obscure and equivocal until their meaning be liquidated and ascertained by a series of particular discussions and adjudications. So this statement appears to refer to statutes or statutory enactments, new laws penned after legislative deliberation. It could also apply to the Constitution, at least to a certain extent. For Caleb Nelson and others, the newness of these laws is significant. So Nelson writes in Originalism and Interpretive Conventions, quote, Madison's comments in Federalist 37 about the inevitable obscurity of written laws were restricted to new laws, whose meaning had not yet been settled by practice. Similarly, while he conceded that the exposition of the Constitution was a copious source of difficulties for the First Congress, he observed that those who may follow will have an easier task. Once precedents had settled upon a meaning within the range of permissible interpretations, Madison expected that meaning to be fixed for the future. So this notion that there will be a set of practices that will expound ambiguous or unclear text and fix their meaning for the future. However, turning back to an earlier part of the same paragraph of Federalist 37 reminds us that practice itself may not be determinative. As Madison explains there, citing the obscurity of the objects of inquiry themselves, the relationship among the branches of government, as well as that among areas of law, had remained sources of conflict within the English tradition, despite the great expenditure of effort and intellect on settling those matters once and for all. And according to Madison in this section, he says, experience has instructed us that no skill in the science of government has yet been able to discriminate and define with sufficient certainty its three great provinces, the legislative, executive, and judiciary, or even the privileges and powers of the different legislative branches. Questions daily occur in the course of practice which prove the obscurity which reigns in these subjects and which puzzle the greatest adepts in political science. The experience of ages with the continued and combined labors of the most enlightened legislators and jurists has been equally unsuccessful in delineating the several objects and limits of different codes of laws and different tribunals of justice. The precise extent of the common law, the statute law, the maritime law, the ecclesiastical law, etc., remains to be clearly and finally established in Great Britain, where accuracy in such subjects has been more industriously pursued than in any other part of the world. So from Madison's remarks, the separation of powers, the division among legal regimes, and matters of jurisdiction all emerge as subjects plagued by a certain indeterminacy despite the best efforts of practice to pin them down. And it is perhaps not surprising that it is these subjects that are still the source of great debate within the constitutional and broader legal contexts. Situating Madison's comments about the liquidation of new laws within the broader context of his statements earlier in Federalist 37 about the failures of experience or practice to settle various kinds of legal political questions that the Constitution addresses suggests the limitations of liquidation in fixing constitutional meaning. While the Constitution itself may represent a radical innovation, it does not always set down new law. In particular, the Constitution's numerous references to the common law and its principles, whether the invocation of habeas corpus in the suspension clause, the reference to natural-born citizen in presenting criteria of eligibility for presidential election, the appeal to concepts like confrontation in the Sixth Amendment, or the explicit mention of common law in the Seventh, embed within this new document a set of legal concepts with a very old history of practice. Nor, in many of those contexts, does the history of practice definitively settle these provisions' meanings. Instead, they sometimes remain as obscure as the distinctions that Madison invoked in Federalist 37 before introducing the notion of liquidation. Alternatively, the history of practice may only furnish a partial gloss biased by the institutional location of those applying the constitutional provision. So I just want to give an aside about that partial gloss of practice. Along these lines, there's an illuminating exchange in the Canning oral arguments, and we've heard a lot about Canning from both Will and Neil, but in one part of the oral argument, as the Solicitor General was arguing for the notion that the phrase may happen could include vacancies happening before recess began, and that the constitutional language is ambiguous, he adduced the practice of past presidents, stating that, quote, maybe the language in the Constitution looks unambiguous to you now, but it has been the subject of contention. It has been thought to be ambiguous from the time of George Washington to the present. And Justice Scalia jokes in response, it's been assumed to be ambiguous by self-interested presidents. I think that joke, though, contains a deeper insight, because to the extent that there's a practice in the recess appointments context, it is a practice of the executive branch. The silence of the Senate before pro forma sessions might be taken as acquiescence, but I don't think this indicates necessarily a consensus among the branches about the extent of the president's recess appointments power. So the practice may be ambiguous, or it may be a practice emanating only from one branch of government, so we might not think it leads to consensus. So considering the Constitution within a longer history suggests that the early practice of implementing constitutional provisions, rather than definitively elucidating those clauses, simply represents one moment within the larger interpretive tradition of the common law. To the extent that practices occurring soon after ratification come into conflict with those happening before it, there may be less reason than has been supposed to weigh those more heavily than subsequent practices that revive the older traditions. As the history of the common law often reminds us, practices that once seemed obsolescent often reemerge, sometimes with new justifications, so that legal revolution often does land us back in what looks like the same place where we began. And I think this raises a point that Justice Kagan addressed in the Noel Canning oral argument as well. Kagan asked of the Solicitor General at one point during oral argument, "General, would you agree that this clause now is not mostly used to deal with emergencies arising from congressional absence? That most modern presidents," and I say this sort of going back to President Reagan, "presidents of both parties essentially have used this clause as a way to deal not with congressional absence, but with congressional intransigence, with a Congress that simply does not want to approve appointments that the president thinks ought to be approved. You know, absence in this day and age, this is not the horse and buggy era anymore. There's no such thing truly as congressional absence anymore, and that makes me wonder whether what we're dealing with here, what's essentially is an essentially a historical relic, something whose original purpose has disappeared and has assumed a new purpose that nobody ever intended it to have." So the response, Verley's response, was to contend, first of all, that the original purpose does remain, but he did acknowledge a new potential function of the Recess Appointments Clause, that of acting as what he called a safety valve in the face of congressional intransigence. So I don't want to come down either way on the merits of this new purpose, but one might conclude that the substitution of a new purpose for the clause, as long as the practice remains within the confines of that permitted by the constitutional text, should pose no difficulty at all. In fact, the trajectory described in the case corresponds quite closely to what Oliver Wendell Holmes depicted as a frequent occurrence in the common law. According to Holmes, quote, "A very common phenomenon and one very familiar to the student of history is this: the customs, beliefs, or needs of a primitive time establish a rule or a formula. In the course of centuries, the belief, custom, or necessity disappears, but the rule remains. The reason which gave rise to the rule has been forgotten, and ingenious minds set themselves to inquire how it is to be accounted for. Some ground of policy is thought of, which seems to explain it and to reconcile it with the present state of things, and then the rule adapts itself to the new reasons which have been found for it and enters on a new career." So unearthing this pattern that Holmes describes in the recess appointments context is not difficult. At least according to Solicitor General Verley's argument, practice in the early republic permitted recess appointments intra as well as intersession and allowed for the interpretation of may happen as including vacancies that occurred before the recess commenced. As it became easier for senators to be recalled under urgent circumstances, the use of recess appointments for emergency situations became less necessary. At the same time, the practices of allowing intra-session recess appointments to fill vacancies that arose prior to the recess lent themselves to implementation for a new purpose, that of bypassing Senate approval when the Senate resisted an appointment for ideological reasons or as a bargaining chip. If one believes that those two practices are, in fact, commensurate with constitutional text, which is another matter, the process of evolution of practice and purpose seems unobjectionable and consistent with the common law developments that Holmes describes. To conclude, I want to argue that the history of practice is relevant to constitutional interpretation, but the relevant practice spans the pre- and post-ratification periods. Nor should examining pre- and post-ratification practice be considered fundamentally different endeavors. The former, the basis for evaluating the meaning of constitutional text, and the latter, a mode of resolving ambiguities within it. And this is where I might agree to some extent with Neil. The two might be thought of instead, in many cases, as an interrupted continuum, ratification slightly shifting the course but not setting an entirely new route. In this way, a kind of common law remains a ground of constitutional interpretation, illuminating mechanisms and limitations of constitutional change, yet we can avoid fetishizing the practice of the early republic and insisting that it represents the only correct interpretation of constitutional meaning. Thanks.
Thank you. All right, we've got plenty of time for questions. I think I'll throw it open with one question to the panel, and then we would ask people with questions to approach the microphones. So my question for the panel is, what's different about this use of practice in the context of constitutional law as opposed to law more generally? That is, to say, is there something different about liquidating the Constitution than about determining the meaning of any other, of a statute or some other provision of law? And if so, what? And that relates a little bit to a second thing that sort of stuck in my mind as the discussion was going on, which was does the liquidation of liquidation matter? That is to say, does it matter how to get, not to get too circular, but over time, how our system has made use of this particular type of material in different eras of interpretation? So those are the questions I thought I would throw open in any order. I guess we'll go back to Will to start with.
Okay. So the first question, I guess, I think the answer is, in theory, liquidation is a property of all law that's put into practice, that all law can have obscurity for all law, the ways in which that gets worked out of a practice, count. I think in practice there's an important difference, which of course is that it's easier to change non-constitutional law most of the time, and so the stakes of liquidation are lower. So in constitutional law there's more anxiety about letting subsequent developments sort of control or alter the text than there is. There's both directions. Like, some people would say we need it because there's no other way to change the text, so we really gotta roll with the practice. Other people would say, no, the whole point of the text, it's not supposed to change, and so we get nervous about practices that deviate from the text. So I think the stakes are in that sense higher. That means that some of the questions like the ones Neil talks about can we really draw a line where liquidation is allowed and where it isn't allowed, probably becomes more important. Whereas in the zone of, let's say, statutory interpretation, because it's much easier to either sort of ratify or abandon the practice, we just may not care as much about whether or not the practice really is faithful to the bounds of the text. I guess I'll also throw out an answer to the second question. So the liquidation of liquidation. I worry this is getting even more meta, but I think it depends on why you care about liquidation. So I think you can be a sort of pure traditionalist or a pure sort of living constitutionalist about liquidation. Where you just say, it's our legal community, it's our practices that matter. The text occupies a mostly ceremonial role, and then I think you care a lot about the liquidation of liquidation. You'd want to know, what is our practice now of dealing with practice? But for the reasons that I guess Steve and I talked about, I don't think you have to have that view of the law to believe in liquidation. And if you're a sort of originalist liquidator, then I think you care much less about the liquidation of liquidation, at least, to the extent it's inconsistent with the original liquidation. And you want to know more about what was the text supposed to do.
The only thing I'd add is just that when we're thinking about law other than the Constitution, there's also statute law or other kinds of written law or administrative regulations and so on, but there's also common law. And that in some ways, sort of what the common law is at any given time is the settled practice that everyone recognizes as, the customs of the realm. And so a lot of legal change can occur through shifts in accepted traditions and settled practice, but that doesn't need to necessarily interact with any enacted text whatsoever.
Can I just add on to that? I think that's part of what I somewhat object to about the use of liquidation as the method of understanding how practice relates to text in the constitutional arena, because it seems very much a statutory principle, or that, at least as Madison describes it, it's about sort of understanding the meaning of newly enacted statutes, and it, I think, leaves to one side this history of larger legal practice that Steve was also talking about in his presentation, I think.
So I would think that for texts that are less determinate, like a lot of portions of the Constitution versus a lot of different kinds of statutes or contracts, there would be more room for liquidation, more room for it to make a difference. I would also think in areas of constitutional law where you're not likely to see judicial review. What happens if the first President Bush crosses the border from Kuwait into Iraq with 500,000 American troops, right? Is that unconstitutional? Is that impeachable? I would think you're going to see constitutional commentators argue a lot about historical practice. You can't just invoke precedent. So you need authority through historical practice in ways that you don't have other forms of authority available. In terms of your second question, liquidation of liquidation, I would say it's not clear to me why, whatever reasons you would have for wanting liquidation, it's not clear to me why those reasons would be exhausted by the earliest practice only. If you think Madison in Federalist 37, and I really appreciated Bernie, right? You're conveying how much is in there and not just the quote about liquidation. He talks about the imperfections of language. He talks about human frailty. He talks about the difficulty of figuring even out the differences among the branches as well between the federal government and the states, right? So if one of the reasons you would want to liquidate is because you think there could be changed circumstances and we don't want to decide how we're going to handle them all now, well then what about radically different circumstances 2 centuries later? If you think liquidation is a delegation by the framers or the founders to subsequent interpreters, well, why only what happens during the Washington administration and not what happens, again, a couple of centuries later when we know a lot more about what's going on in the world than they did as well. So I would hope that the liquidation of liquidation would not be narrowly focused on what happens in, say, the first couple of decades under the new Constitution.
All right, Michael.
So I'm wondering about what the practice is with respect to abandoning the practice and going back to the original view, which sometimes happens. I have a couple of examples. Crawford against Washington for many, many cases. So these are not just 1-5-4 decision that they decide are wrong, but a long practice of interpreting the Sixth Amendment as, you know, a multi-factor fairness test. Then all of a sudden the court looks at the history and they say, well, actually the original intention was something else, or original meaning was something else, and they go back. Erie Railroad is another example of this. It doesn't seem illegitimate to do that, but I'm wondering what, within the theory of liquidation, when is it permissible for it sort of to become unfixed and to move back? And is that motivated only by a realization that there was really clarity at the beginning and therefore, you know, they got it wrong all that time? Or is it motivated partly by the imperatives of current events, or is it by the increasing incoherence of the doctrine into which they had fallen as a result of liquidation, or what is it that leads to a legitimate leap back?
And I'd like to just add to the question by asking the reverse, which is not a leap back, but a leap forward. Are there ever circumstances where you do have accumulated practice and you say, instead of we're going back to an earlier practice, this just isn't working. It's no longer functional. Something has changed, and we need to abandon what we've been doing. So sort of the flip side of the question.
I mean, I would say that the answer to both of those depends a lot on sort of what you think the Constitution requires, and sort of it's hard to answer those questions in isolation. I mean, in particular, sort of the leap forward question, sort of leap forward to what? What is the rule that we think is legally operative that we are abandoning the present practice for? In the context of sort of leaping back, the story is usually something like, this was the governing legal rule, we messed up and we forgot what it was, so we need to, return to it. One can disagree about the examples. I might think that Erie is not, a return to the original rule, but rather an abomination that must be destroyed along with all of its works. But that is whether you're able to sort of unliquidate or reliquidate depends on what theory of liquidation you're using and why you think it's part of the law. So if your story of why it's part of the law is, this was a rule of legal change that applied at the founding and we haven't gotten rid of since, and using it, they attempted to liquidate the following text. And either they got that wrong in the sense that they were trying to change the meaning of something that was clear, or they didn't. They did it the right way, and now that's binding on us. And was it part of their rule of liquidation that something could get liquidated again a second time the other direction, or was it not? So there are going to be a lot of questions that are sort of built up in there that one can't give necessarily a unitary answer to, that depend on why you think this thing is part of the law.
But don't you need to give a unitary answer if this is going to be anything other than just arbitrary?
Well, you need to give you need to give an answer ultimately. I don't know the history on this point, so at the moment it's an answer on which I am ignorant. But what I mean to say is that one can't give a unitary answer about liquidation, period. One needs to say, this is my story of the history, this is my story of the jurisprudence, this is why I think liquidation is actually part of American law, and depending on how persuasive your story is, whether we believe you, whether that's the correct account of American law, that's going to give you different answers.
So this is my theory, this is my story. I would say there are two different ways to reliquidate. And sometimes they get collapsed and they may not really be as distinct as they seem, but in theory, one is the kind of the rediscovery myth. So we've been doing it this way for a long time, but like lo and behold, we now realize it's very clear we've been doing it wrong. Maybe that's because Charles Warren finds a ink-stained piece of paper in which he claims that the new meaning of the Rules of Decision Act is suddenly revealed to all, or historical records do become more available. Sometimes we learn things. Or maybe it's more, as Neil suggests, maybe our decisions to find things clear are in fact kind of constructed in a much more complicated way, and it's not fully objective what's going on, but it's hard for us to ever get outside of ourselves. So it's hard for us to ever know, does this seem clear to me, even though it's not really clear because of something else, or is it really clear? But so I think that's one way. I think in both Crawford and to some extent in Erie, though, there's another thing that's going on, which is that sometimes fixed practices kind of decay, not necessarily on purpose, not necessarily because somebody's trying to decay them, but the court says this in Crawford, kind of that one of the things that's going on with our current rule, Ohio versus Roberts, is we don't even really know what we're doing anymore. There is no real practice because the test is so mushy that there is no one thing that's become fixed, and I think that gives you authority to kind of start over without needing to say the original meaning sort of was clear and trumps it. You just say we tried to have a practice for a while and maybe we did, but now it's kind of fallen apart. And that happens with precedent sometimes too. I mean, the court will say it's become unworkable, which sometimes means we just don't like it. It produces answers that we just cannot bear. But sometimes it means we really don't know what we're doing anymore, and even when we try, there's not enough coherence there. And I think that's a different way to reliquidate. I'll also hazard a guess much more tentatively about going forward. And I'll say I think it can be, I'm skeptical of going forward in a decay situation where the practice really, there is no kind of there. Going forward makes a lot of sense. We just start trying to make the best interpretation we can with what we have. But if you have a kind of a fixed practice now, and you want to get rid of it for something that's also not clearly required, I think there's at least we start asking sort of hard questions about authority. It depends on who is doing the going forward, but usually we're talking about government officials. And the question is, why do the government officials have the authority to replace our current practice with something that is neither the thing we all do now, nor the thing we agreed to in the text? Are they our agents? Who appointed them agents for sort of constitutional change? And I think that's something I worry about a lot with deliberate replacement of a current practice with something totally new.
I just want to say that I think that the answer to Mike's question may depend on which view of liquidation you take. Is it an interpretive principle itself, right? So is the liquidation of practice part of an early interpretation of the Constitution, and that we're giving authority to those practices as interpreting these ambiguous provisions? Or do we think of the practice as more of a continuum, that it's the practice itself that we care about, rather than simply as an interpretation of ambiguous text? And so I think if we imagine it as interpretive, then we might say, well, if you find actually their history is wrong, there was a clear original meaning of a clear set of practices prior to ratification, then we have to go back to that clear set of practices that determine the constitutional meaning. If you think of it as more about the practices that persist after the founding, then it might be much harder to say we're going back to the original meaning rather than this continuum of practice, unless you say, well, actually we have a whole set of past practices, including pre-ratification, that we can invoke, and we can go back to those pre-ratification practices as well as the post-ratification ones. Now, responding to Jenny's question, I think I want to say that I'm not sure I want to oppose going forward so much to going back. I think that for the reasons that Holmes is sort of talking about in the evolution of the common law, going back is often going forward, or vice versa. So that I think that you might say Crawford is going forward in certain ways as well as going back. So I guess I think that I would want to question that distinction.
So if I can just say something briefly. Michael, you asked a hard question because you asked about when it's legitimate and not when it's going to happen. And my unhelpful, responsive response to you is, tell me what your approach to constitutional interpretation is. If you're a relatively thick originalist, and you think it's original semantic meaning, or you think it's original intent or something else, well, that ought to be, if you mean what you say, the fact that it's really clear, that ought to be enough by itself. And if it's not really clear, then other kinds of considerations probably shouldn't be relevant. If you're more of a pragmatist or a pluralist and you think it's really about the different strands in a rope, then you're going to look at a variety of modalities and make an all things considered judgment about what makes most sense. What I can tell you as a descriptive matter, which you didn't ask about, but I want to point out, is I think Crawford's a great example. It was the term I was there. It was the sleeping bomb, right? People were focused on the terrorism cases and on the Cheney Energy Commission and on the Newdow pledge case and on McConnell against FEC, and then Crawford happened. And when the term was over and the justices fled to Europe, right, people realized what they had done. But I can tell you that I don't think the justices in the Crawford majority thought that this was going to have terrible, devastating consequences for American society. I don't think the justices who decided Erie thought that as well. Now, judges don't tend to talk that way, but I think you're unlikely to see a going back or a leap forward if the justices in the majority think it's going to have absolutely terrible outcomes, but there's nothing we can do. And we can debate whether those kinds of concerns are internal to law or external to law. To the extent they're external to law, I don't think it's politics in the low sense of partisanship. I think it's judges understanding that they have to take some account of the conditions of their own public legitimacy, and those are the kind of people I feel most comfortable trusting with power.
Eric.
Thanks. When we talk about liquidation or practice giving rise to liquidation, I think we're generally talking about a practice of someone doing something. So Congress creates the bank, the Supreme Court upholds it, and that gives rise to liquidation. But from time to time, we come across arguments that the practice of not doing something shows what the Constitution means. And I think the healthcare case is a good example. Part of the argument there is that Congress can't possibly have the power to require people to buy insurance from private companies, because if it did, it would have done all sorts of similar things in the past. So I guess what I'm wondering is that type of argument also an argument about liquidation? Is it a legitimate type of liquidation argument, or is it kind of its own phenomenon, and can it lead to problems such as sort of locking us into the absence of doing something and being unable to adapt to new conditions?
It's a great question. I think the healthcare case, unprecedented, right? It's, and then, what do those who defend the law say? These limits you're going to impose on Congress are unprecedented, right? So it's a case about limits and a case about limits on limits. And both sides are screaming unprecedented. I think commandeering, right? New York and Prince, right? There's an inference from a longstanding failure to commandeer that the people understood was unconstitutional. And I myself tend to think that it's a very vulnerable argument. On the one hand, it's unprecedented. On the other hand, there's a first time for everything. Everything was unprecedented the first time it happened, right? And you would want, it seems to me, to actually, if you're genuinely interested in what people used to think, or what people have thought about the law throughout American history, you want to have more evidence than just the fact that there's silence, right? One possible reason Congress hasn't required people to buy things against their will before is because they all understood it was unconstitutional. And then in the 90s, right? Conservative Republicans in Congress and in think tanks came up with this idea of an individual mandate in response to the Clinton plan, and no one thought it was unconstitutional, but the Democrats didn't like it. And then a decade later, it's not only unwise, but it's unconstitutional, right? That's one story that just no one ever thought they had this. The other story is, politically, why in the world, if you're Congress, why would you want to engage in this practice a whole lot, given how unpopular it's likely to be and given how many other regulatory alternatives you have to accomplish your objectives? And by the way, it wasn't actually a mandate in the healthcare law. It was a modest financial incentive, right, which in my view the court appropriately upheld as a tax. But even if you disagree, the fact that Congress hadn't done it before, it just doesn't seem to me, if that's all you have to infer unconstitutionality, then you don't have very much.
I would just want to add that I think there are changing historical circumstances, and you can see this from the history of clauses that have been used a lot and then fallen into really obscurity. I mean, the contracts clause is one example. It was used so often in the 19th century, and then now, we really have very few contracts clause cases. So I think we can see it from the opposite perspective. There might be certain clauses that there was no real need to litigate or need to think about or use the powers under it, but suddenly the circumstances arise when those can be deployed.
I'll just say, I think the important difference is not between sort of doing versus not doing, but it's between discussed versus not discussed. Right. So nobody ever talks about the mandate either way. So we just don't know. Is that because they secretly all thought it was unconstitutional, or is that because they just had no reason to do it? On the other hand, if I can plug something I wrote, with the
that's so inappropriate at a forum like this to plug your own work.
There's precedent for it. With the federal eminent domain power, for example, Congress doesn't exercise eminent domain in the states outside of the territories for the first 80-some years. But it's not like nobody ever thinks about it. Every 20 years or so, somebody says, hey, we should exercise federal eminent domain. And then a bunch of people in Congress say, oh, no, we can't do that. It's unconstitutional. Remember the last time we talked about this and we agreed it was unconstitutional? And you have a series of discussions and votes in which it gets voted down. And I think it is sometimes harder to read into a no than a yes still, so there's some caution. But I think the big divide is that when you have those kinds of discussions and then a defeat of a proposal, that is something that you can draw some kind of precedential weight from that's very different from the sound of silence.
All right, next question.
This is a question for Will, but for anyone else on the panel as well. I was thinking of Will's example of the bank and Madison, and I think he might have mentioned removal as well. And I'm wondering whether Will or other panelists think that someone like Jackson violated the Constitution when he vetoed the bank bill because he failed to see the liquidation that had occurred, or whether the Congresses that had placed restrictions on removal after the decision of 1789 also had violated the liquidated version of the Constitution early on. Because I think that's what's implied by the notion that the Constitution somehow authorizes liquidation. Welcome your comments.
So on Jackson, no, I don't think he violated the Constitution, but in part because what he did was veto, and you don't have to have a constitutional objection to use the veto. I mean, you can. That's a common reason to veto something that's unconstitutional, but you can also just do it because you don't like it. So Jackson's actions are perfectly fine in the sense that the bank could have been established to be constitutional, and he's still allowed to veto it. Then you've got the speech where he says it's unconstitutional, and I think that is an interesting thing to try to think about. I think that gets into the question of unliquidating and unsettling. My inclination is to say that rhetoric that's inconsistent with the current constitutional settlement is okay, that you're allowed to be an outspoken critic of the constitutional regime, and that actions are things to wonder about. As to removal in 1789, I do think that's a place to think about liquidation, and Madison, during the removal debates, I think presciently says that this is going to be a precedent that people are going to look to for the scope of removal power. I haven't done all the historical work to know exactly how settled it is and so on, but assuming that the decision of 1789 and subsequent decisions really are a liquidation, then yes, I think Congress is violating the Constitution by imposing removal restrictions.
I would say that the theory of liquidation, as I've perceived it, is that it was a rule of legal change at the founding that the Constitution's unclear provisions could become fixed through the following process. And if that process occurred in the removal debate and then Congress tried to impose a different rule, then yes, it would be violating the Constitution. We might, I don't know whether, in fact, it is true that liquidation was such a rule and that it had the following features. But that would be the sort of legal historical claim that one would have to make.
It's a great question. If you say once the practice becomes liquidated, right, then you are either wrong or violating the Constitution by not following the practice, then how would the practice ever change short of a constitutional amendment? The practice has the same status as completely determinate text. And I think part of what your question is pointing out is that historical practice, right, is contestable in a way text that is perceived to be crystal clear is not. Right? There's something special about the text as opposed to practice. And I think people do contest the practice, and they do it all the time. And as a result, right, the practices aren't frozen at a particular point, but in fact move in history.
I just want to resist one thing Neil just said, which is that sort of the question of if it's fixed and binding, does that mean it can't change short of a constitutional amendment? Because sometimes, and this is not a conception everybody has about law, but there are some things that nobody is allowed to violate, and yet they can change, like the rules of grammar. So, like, you're supposed to comply with the rules of grammar. No individual person has the authority to say, like, I'm striking out in a new direction and establishing a new grammatical rule, and yet they do change, not through through human action, but not human design. I think that happens to practice too.
Can you give me an example in practice in which everyone agrees that they're obliged to follow the practice, and in following the practice because they're obliged, nonetheless the practice changes? Like, how does it change? What causes it?
Well, so sometimes it happens by accident. So I think with recess appointments is a good example. I mean, there have been subtle changes in interpretations of the recess appointments clause over time.
So people make mistakes. They don't meet their obligations.
I mean, isn't this the primary motive, the primary primarily accepted mode of common law change? I mean, the picture was, a judge, at least in the pre-modern period, a judge wasn't supposed to say, I am revising the following common law rule. You have to abide by it. But it might come to pass that if what the common law is settled practice, that settled practice might change through mistaken rulings over time in the same way that grammar changes over time, even if everyone thinks they're speaking properly when they do it.
Yeah, I just don't find that to be a descriptively persuasive account of common law legal change. That is just an aggregation of mistakes among judges who are deluding themselves.
You don't have to say necessarily be deluding themselves, but in the same way, I mean, think about grammar. We use different words than they did then. There are transition periods. We're not sure right now whether it's okay to split an infinitive. But eventually it might come to be the case that sort of the most orthodox grammar textbook you can find says splitting infinitives is just fine.
But I don't think we all feel duty-bound to follow the extant rules of grammar that was taught to us in elementary school. I think people play with language and speech and grammar all the time, right? I mean, you start using colons in creative ways.
I don't think we necessarily feel that we have a moral duty to do so, but certainly grammatical rules are intensely shaping our practices in just how we're talking to each other right now in ways
and our practices are shaping our grammatical rules.
We can't just be creative. Like, you've never put a colon in the middle of your first name.
Oh, I just did, man.
The professor formerly known as Neil Siegel.
I think it might be time to move on. Michael.
Thanks. Mike Ramsey, University of San Diego. I might quickly suggest on the exchange you were just having that an example you might be adopt is customary international law, which everyone is supposed to follow, but nonetheless changes as a result of people not following it. But the question I had is a distinct one. It's about the scope of the liquidation. What gets liquidated? Is it a specific practice or is it a more general rule? And so let me give an example to illustrate this. Let's suppose that the original understanding of the president's war power is unclear, something that I don't really think is true, but let's assume that it is. And that over time, the president exercises independent war power in certain types of circumstances. And there's no significant resistance to that, so it's accepted. Now, what does that establish? Does that establish the proposition that the president can use independent war power in those particular types of circumstances? Or does it establish the proposition that the president can use independent war power, full stop? And how do you know the difference?
In some ways, I might sort of throw the example right back. I mean, it's the standard customary international law question of how do we infer a custom from individual points? How do we connect that line? Part of it will depend on what is perceived to be at the time the thing that these actions are standing for, what the nature of the defenses of them are, the types of reasons that are advanced for their legitimacy. But this is being able to generate customary rules from individual acts is a problem sort of throughout law and human society. Whether it takes exactly the same form in the liquidation context as it does elsewhere, I couldn't tell you. But it seems to me that that's not sort of so much of a theoretical problem as just an empirical question about what are the doctrines of liquidation prevalent in this particular society, and do they do something other than what one would normally perceive sort of the practice to be?
I'd say I think we care about the shared rationale. So it sort of depends on, this is maybe the same, like, what did people say was the reason they could do it, and was that the thing people agreed on? So if the president says, my actions stand for the proposition that I can always do whatever I want, but the people who acquiesce or tolerate it say, no, well, we're letting this one go because the Barbary Pirates is complicated and, we have reasons, then we would say we've liquidated the Barbary Pirates question and we're still contesting the broader question. And that part of the advantage of looking to things that are actually discussed and debated is that then we have that to go on.
Well, this question comes from someone whose proximity to the Supreme Court is reading New York Times and reading the Wall Street Journal, so not quite as close as the rest of you. But there's a perception among the world that the justices tend to decide what they want to do, and then, like a housewife going through Whole Foods, pick things off the shelf that fit what they want to do. So I'd be interested in your comment on that and how much the type of intellectual discussions that you folks are having here, which are extremely interesting, actually happen other than in academia. Do they happen on the bench?
Yeah, it depends. I mean, first, I think they happen in a lot of cases that, don't tend to be extensively covered in the Times and the Journal and the Post. There are a good number of really just technical, difficult cases, and they're not particularly ideological. And the hardest case my term was, it was an ERISA case. And basically, Congress said, come in one part, and said stay in the other part. And no one knew what to do. In fact, I didn't think any of the justices knew what to do. There was one clerk in the Breyer chambers who was an ERISA freak, right? I think he knew what to do. And eventually it ended up, they came to a decision, but it's not clear that anyone even knew if it was the right answer. So there are those cases, and there, in which you don't, they're just trying to figure out the right answer using good lawyerly legal tools. The big ticket cases that are heavily ideological, in which there seems to be a real investment in the outcome, either for reasons not having to do with partisanship, or in rare cases, it makes you wonder. I mean, I think that happens too. What the relevant percentages are, I don't know, and I don't know that anyone knows. I think it's so much depends upon I said this yesterday, what do you mean by law, what do you mean by politics? And the more demanding you are for the justices to act legally, right, the greater the demands you impose, then the more often you're going to be disappointed. In the recess appointments case, I mean, I think this substantiates the concern. It's as if some justices on the left are robust defenders of presidential power, and some justices on the right, who used to be robust defenders of presidential power, now seem to be robust defenders of congressional power. And it's hard for me to believe that if this had come up back in the Bush II administration, you would see the same lineup on the court. And it doesn't mean that they have bad motives and they're just partisans, but it may mean that, like the rest of us, the way the case is presented and how they feel about things going on in the world shapes how they react. So in the recess appointments case, it's so not a partisan issue, unless you think that Republicans are never going to win the presidency again, which would be a foolish thing to think. And yet the justices are seeming to line up in a partisan way, and that I think is regrettable.
Any more? Barry.
Good morning. So I don't know the gentleman in front of me who just asked that question, but I'll be talking about it later this afternoon, so you can hear more. I enjoyed the panel, and I would not have gotten up at all until there began the conversation that involved putting a colon in Neil's first name. I'm not sure if it's now Neil or Neil, but anyway, I'm all for constitutional change. The word that you were using that made me hop out of my chair was mistake. It was this idea, I think, that liquidation happened by, weird permutations where things had gone wrong, and I'm just not sure that's an accurate description of how I understand the common law or constitutional change. So, whether it's decisions about how the United States goes to war, or how the filibuster is going to be practiced, or even something as sort of down to earth as the rules by which people get counsel in certain kinds of cases. I think the common law is an apt analogy. It's just that there always comes a case that doesn't fit exactly like the case before, and so we deal with it as best we can. And whether it was a mistake or not, we often don't know until much further down the road when we can figure out whether any particular decision was off the equilibrium path. And so just a plea to say that is actually how we liquidate constitutional meaning, I think, and I'm not sure it necessarily depends on mistakes.
Responses?
I don't know. Sometimes coercive decisions will occur that no one would say were a mistake. I mean, think about a situation where you've got some sort of norm. There's a core set of applications. Everybody would agree, yeah, the norm applies that particular way. There are penumbral cases where we're not really sure how the norm applies. We have a bunch of those. They all seem to sort of fit a line. At the end of the day, we say, if I'm looking at all the dots on the plane, maybe we really have a new norm. Maybe that new norm is a better way of explaining what we're doing. I think that would be one way of talking about sort of common law modes of legal change. Then we have the separate question of is common law mode of legal change the mode of legal change? Is that the one we actually accept for all kinds of law, written as well as unwritten? And people might have different views on that. And sometimes there are situations where the law in practice changes in a way that's sort of utterly unreconcilable with our commitments about how law in theory is supposed to change. So we might say, I'm looking at Johnson versus Surface, and I'm having a hard time fitting this into prior understandings of the right to counsel. Whether you think that means that it's wrong is a separate question. Depends on sort of your broader constitutional theory. But a lot of times, the changes in practice might very well be identifiable as mistakes, whether or not we still regard them that way today.
So I think mistake may have been too pejorative, but I think I'm thinking about something slightly different, and maybe it's better to think about it in both internal and external terms. So sometimes we have a practice where most of us looking at it would say, the text is ambiguous and the practice is pretty clear and settled, and so it meets the criteria for liquidation. But there are dissenters there. There are either people who actually they think the text is clear in some directions contrary to the practice, and so they start striking out against the practice, or they don't believe in this liquidation stuff at all, and for whatever reason they again start striking out for their own vision of the Constitution, or they dispute what the practice actually is, and again they make moves. So sort of internal to them, they're not making a mistake, they just disagree. And then sometimes the people who disagree then succeed at unsettling the constitutional settlement or pushing it in a new direction. And so from some external perspective, I called that too quickly a mistake, in the sense of it's somebody violating the shared set of rules about settlement. But at the same time, they're doing the right thing from their perspective, and sometimes, they win, and winners write the history books.
And just also to say, it's not like there aren't mistakes. Correspondence is a mistake, but we know that after the fact, because we see the lines. We sort of see the lines where the outlines are.
Yeah, it depends on one's theory of law. I mean, some things are mistaken the day they're decided, and we don't really, and one can say that based on the norms as they stood at the time. You can say, the Supreme Court has decided this case, we don't think it's going to revise it anytime soon, but the decision was wrong. I mean, lawyers make statements like that all the time, and we understand what they mean when they say that. It depends on a particular theory of how legal change works to be able to say we don't really know whether it's a mistake until we've seen the development of the cases after. I think that on alternative theories you can say no, we can actually know right away.
We're just about out of time, but I want to give Neil and the colon in the middle, and Bernie, I'm putting colon in there too, no, a chance to give any final remarks.
You go, Barry.
All right, we'll take a brief break and resume at 10:30 for the next.